The Honorable Supreme Court of India has permitted the withdrawal of life-sustaining treatment for Harish Rana, a 32-year-old man who has been in a vegetative state since 2013 after a severe head injury. Now, this marks the first Indian court order approving passive euthanasia in such a case. A bench of Justice J.B. Pardiwala and K.V. Vishwanathan allowed the withdrawal of a medical treatment, including clinically assisted nutrition, being provided to Rana. The court also directed AIIMS Hospital to implement a palliative end-of-life care plan, ensuring that his final stage is managed with comfort and with dignity. Now let's first understand about euthanasia, then what is passive euthanasia, and about this case in detail. First of all, euthanasia is the deliberate, intentional act of ending a person's life in order to relieve them from persistent, unbearable suffering which can be caused by any incurable or terminal illness, a condition of irreversible coma, or a persistent vegetative state. Now, this term derives from Greek roots meaning good death, eu for good and thanatos for death, and is often framed as an act of a mercy aimed at preserving dignity in the final stages of life. Now let's understand about the background of the case. See, first of all, Harish Rana has been in a vegetative state since 2013, following a fall that caused severe head injuries to him. In 2024, his father approached the Delhi High Court seeking permission to withdraw life-sustaining treatment. Now, initially, the Honorable High Court rejected the plea, stating that Rana was not terminally ill. The family subsequently approached the Supreme Court of India, which reconsidered the case based on medical assessments. It's a very important update. And in 2025, the Honorable Supreme Court of India constituted primary and secondary medical boards to assess Rana's condition. Now, both the boards, they concluded that his condition was irreversible with at least negligible chances of recovery actually, supporting the decision to withdraw the treatment. Both the boards said that the chances of recovery is actually irreversible and they should withdraw the treatment. Court's ethical perspective in this was, see, Honorable Supreme Court of India emphasized that the decision was not about ending life, but about avoiding the artificial prolongation of life without the hope of recovery. That is actually the opinion of Honorable Supreme Court of India, and it described the case as lying at the intersection of love, loss, medicine, and compassion, stressing that dignity must guide end-of-life decisions. Now, since we understand about this, there's a distinction between active and passive euthanasia. The court clarified an important distinction. Active euthanasia is assisted dying. Actively causing death remains illegal still. Passive euthanasia is withdrawing or withholding life-sustaining treatment, may be permitted in limited circumstances. This distinction here is very, very important. And there were several guidelines which were laid down in the Schonbach case. Since no law existed on euthanasia at that particular point of time, the Honorable Court created interim guidelines. First was the request for withdrawal of the treatment could be made by family members, doctors, or a next friend acting in the patient's best interest. Then the approval from the High Court is required, and a two-judge bench would decide the case after consulting a committee of 3 doctors. Now, despite setting the guidelines, the court did not allow withdrawal of treatment in Schonbach's case, noting that she still showed signs of life and the hospital staff caring for her opposed the request. And then there is another case, which is Common Cause case of 2018. Now, Constitution Bench expanded the legal framework, and key rulings it included the right to die with dignity is a part of Article 21, right to life. Now, withdrawal or withholding life-sustaining treatment is permissible because it allows the natural process of death to occur. And the court recognized advanced medical directives like living wills, allowing individuals to specify in advance whether they want a life-prolonging treatment or not. But there were several practical difficulties in implementation. See, the 2018 framework had complex safeguards, including advance directives signed by 2 witnesses and countersigned by a judicial magistrate, multiple approvals from medical boards and authorities. Now, these procedures made implementation very, very difficult, and which is why simplification of the process in 2023 took place. In 2023, the Supreme Court simplified the process for passive euthanasia especially, Key changes it included: advanced directives can now be attested before a notary or a gazetted officer. They can be stored in digital health records. And hospitals must form two medical boards, primary and secondary, with the experienced doctors. The collector's role and the mandatory magistrate visit were actually removed. The hospitals must still inform the magistrate before withdrawing the treatment. That is very, very important. And as of March 2026, the Parliament of India has not enacted a comprehensive dedicated law governing euthanasia or end-of-life care in our country, relying instead on evolving guidelines established by the Supreme Court of India. So that's all about passive euthanasia and euthanasia laws in India. Now the larger question remains, is that how can India build a better support system for terminally ill patients? See, first of all, what we can do is we can establish a national palliative care mission. A dedicated national palliative care mission modeled on the National Health Mission of 2013, which should be launched to train the healthcare workers and set up pain relief clinics. And also ensure that essential drugs like oral morphine, which is to manage severe chronic or cancer-related pain, are available in every district. And then we can have an integrated public health system as well. Palliative care must be integrated across all the levels of healthcare, from primary healthcare centers, PHCs, of course, to district hospitals, and coordinated with programs which are very famous, of course: Ayushman Bharat, the National Program for Non-Communicable Diseases 2010, and National Program for Healthcare of the Elderly 2010. And then last but not the least, legal literacy and living will is must. Mass awareness campaigns must be there to educate citizens about advanced directives, living wills, and hospitals. They should employ trained patient advocates to discuss end-of-life wishes with the family. And alongside all these things, we need to strengthen family and community support system. A comprehensive caregiver support model must provide respite care services, home care training, psychological counseling for families. And community-based care should be revived by training local volunteers, which can be replicating Kerala-based neighborhood network in palliative care, providing home-based care for chronically ill and dying people. And also, we need to ensure financial protection. Outpatient, home-based, hospice, palliative care must be fully incorporated in Pradhan Mantri Jan Arogya Yojana, PM Jan Arogya Yojana, and the Ayushman Way Vandana scheme for the senior citizens, covering essential medicines, symptom management, and caregiver support to reduce catastrophic health expenditure. Now, all these things, if done, India's healthcare sector would be given an impetus. Now, one thing which we must know about when we discuss about euthanasia, passive euthanasia or active euthanasia, is that this is not just a medical term, or this is not just a medical issue. This is an issue of life. This is an issue which involves morals, which is that, is it right to take someone's life or is it wrong? And is it right for us to do mercy killing? Because it is not us who should decide that a person should be living or a person should be dying. So there are a lot of moral questions arising in it, a lot of value-based questions arising in it. Plus, there are legal issues which are arising in it as well. Right? So it is a culmination, it's a intersection of all these issues, and it is an intricate issue, which means it's not a simple one. There are different examples in the world where several countries have allowed passive euthanasia, several countries are against it and have banned it completely. But our approach should be to look at the best practices around the world, different case studies around the world, and take a rational, a logical, plus a moral and value-based decision. Now, the decision of Honorable Supreme Court of India is in front of you. What do you think about the issue, and do you support passive euthanasia to be legalized in India properly or not? To do let me know in the comment section. I hope you gained a new perspective from this session. All the very best and have a beautiful day. Thank you.